Chriswell, and the segment is called Martial Law. This radio program intended to be for informational purposes only. The information does not constitute legal advice. The law constantly changes, and so does the information. It might not be complete or correct depending on the date in your particular legal problem. Each legal problem depends on its individual facts, and different jurisdictions have different laws and regulations. Because of these differences, you should not act or rely on any information in this segment without seeking the advice of a competent attorney licensed to practice law in your jurisdiction for your particular problem. There's one of those right across the microphone from me right now, as a matter of fact, and he is Marshall Chriswell. Good morning.
Good morning.
I envied you being able to walk up the street on that beautiful, gorgeous morning, huh?
Oh, what a day.
Yeah, absolutely. It's gorgeous outside. Well, you know, we look at the beautiful weather outside, and we see that folks are out and across the street at the church. They're continuing wrapping up the big roofing project they've had over there. Those folks are working. There's a gentleman across the street. He's walking to work this morning. Some folks, unfortunately, are not able to go to work today because they don't have jobs. And for some people, that's a long-term proposition, and that gets into issues of compensation and being able to get your unemployment benefits. Let's talk about that a little bit this morning. That's okay by you?
Sure, yeah. I handle cases for folks who have been denied for unemployment benefits. And so, whenever it's important, number one, to say, if you have lost your job, it's important to apply for benefits right away.
Okay.
And then once you receive a notice, you'll in a timely manner, you're going to receive a notice whether you are eligible or not eligible for those benefits. If you are not eligible, the biggest thing to remember is that you have a very short window of time in which to appeal that decision. It's 15 days. If you don't appeal within 15 days, you're out. You're done. Yeah. So that's hugely important to get to an attorney, have them review they'll be able to review the file that's on file with the unemployment office and all of the notes in there and the reasoning from your employer and from the unemployment office as to why you're ineligible for benefits and determine whether you have a meritorious case for appeal.
Are there typical considerations that would mitigate against somebody getting their benefits? Are there things that you know to look for because this is usually what happens in this case and this is why they're denied?
Sure. The biggest reason that I see for reasons that employers say that their employees are not eligible for benefits is willful misconduct at work. You violated some rule of the employer, and that's far and away the most common reason that I see. And I've won a lot of those cases because the employer really has a lot to prove at a hearing. If they fire you for willful misconduct, they've got to prove that it's willful, that you knew about the rule. So they've got to present an employee manual or some other evidence that you were aware of this rule, that the misconduct was material to the job that you were performing, that it wasn't something that was didn't really have to do with your job function. Those kinds of things, they've really got to prove their case. And, so that's why you need to have that hearing. Okay.
So that's one of the biggies right there. Are there others that are just basically procedural that would mitigate against someone getting benefits?
Well, if you are working again, a lot of times what happens is someone loses their job and then they start working. Maybe they become self-employed and they start earning income that way. Well, should you be able to collect unemployment or partial unemployment while you're self-employed or while you've got another part-time job or whatever? So, and there are that becomes a complicated legal issue, and there are lots and lots of cases from the Commonwealth Court here in Pennsylvania interpreting those kinds of issues. What if you had just kind of a part-time, what they call a sideline job while you were with your regular employer? You were consulting or something, and then you get fired or laid off, and you still have that consulting business. Should that preclude you from collecting unemployment or partial unemployment? Yeah. So those kinds of things come up as well.
I would assume that as an attorney, you have to constantly update yourself on changes in unemployment compensation law, and most folks probably wouldn't know that even that there are such changes, but I would guess the rules change pretty often. Is that the case?
Well, the legislature can change statutes at any time. The rules can change. The regulations can change. But what changes more often are the ways that those laws and regulations are interpreted by the courts, because that's what guides all of the determinations. It's okay. What does the law say? What do the regs say? And then how do the cases that have come out of the appellate courts, how do they interpret those laws and regulations? And that's what changes, because you have cases being taken up on appeal all the time, just like any area of law, and those decisions coming down, which constantly move the needle one way or the other with respect to all the different legal issues. So it's hugely important that in unemployment and any other area of law that an attorney keeps himself abreast of what's going on in the appellate courts.
When a court makes a ruling that seems to be in contradiction to a previous court ruling, does that throw the whole system into limbo, and you have to really scramble in order to be sure of exactly what's going on?
It certainly can. If you have, if the courts have decided an issue a particular way for many years, and you think, okay, this is pretty consistent, and then something changes, and they decide they decide the same issue in a different manner. Yeah, and it depends on how big the difference is. Sometimes the facts of the case are just different enough to that there's a distinction to be drawn there. And what lawyers are doing is looking at the facts of their own cases. So if a client comes to me and says, "Well, I was fired for willful misconduct, and here are the reasons, here are the facts of the case," I've got to take the facts of the case that they give me and apply it and compare it to the facts of the case that the cases that the appeal courts looked at. Mm-hmm. And if those facts weren't identical or sufficiently similar, then you have to look at whether those cases actually apply to your situation or not. So it's it's a constant a learning process, and yeah, you're right, just updating yourself on the law, because you can lose a case if you don't know that I can have a case that I should win, but I might lose it if I didn't know that there was this new appellate case out there.
Many people, I am sure, when they are terminated from their job, it's a shock to them, and they did not see it coming. What are some of the things that people in those situations need to know? They come to work expecting they'll have a normal work day. They're called into the office. They're told, you are no longer needed here, and we're terminating your employment. What are those first few things that they need to do right off the bat in order to be sure that they are legally covered in terms of unemployment compensation? Right.
Well, the number one thing is to apply. You've got to call, or you've got to go into the unemployment office, and you've got to make that application. That's the first thing that you have to do. And then, also if you can get a written explanation in any form from the employer as to why you were terminated or laid off. If it's a layoff, they're probably going to give you a written explanation, or at least a notice that you're being laid off. That's fairly common. Doesn't happen all the time, but you just want to make sure there's a record.
Yeah. From an employer's standpoint, for instance, I'll give you an example. I got a call from an email from downstairs saying this employee who's not been with us for a couple of years has applied for unemployment compensation and it's been denied. His claim is that he was terminated. Do you have any documentation of when he informed you that he was no longer going to be working there? Because we all knew that he had not been fired, but he had quit.
Right.
So I went back through, and after a lot of searching, found his resignation email. I would guess from an employer standpoint, there are certain check marks that he has to make as well.
Yeah. From an employer standpoint, if you have an employee that is problematic, if they're violating workplace rules, showing up late, not showing up to work, whatever it is, any good human resources person is going to tell you that those things need to be documented. And really the best thing is to have an employee manual with a policy in place for discipline Whether it's okay, you're going to get a verbal warning, a written warning, a second written warning, and then you're fired. Whatever it is, and actually follow that policy and document each step along the way. So that, in the event that that this employee is terminated and applies for unemployment insurance, then you can go in and let's say that they're granted their unemployment, it's approved, and you appeal it, and you go in and have a hearing. You can present in a credible way exactly what happened. It's going to be fresher in your memory because you have the documentation. Plus, obviously, you have all those documents you can set right in front of the referee who handles those hearings, and hopefully win.
Good idea for employers who don't have a legal department to say to themselves today, maybe I need to talk to an attorney and set up, just so I know what I'm legally responsible for, some sort of procedural thing.
Yeah, a lot of small to mid-sized companies maybe don't have an human resources person, human resources department, don't have in-house counsel, an in-house attorney. I think it's important to have a relationship with an attorney who that you can call with these kinds of questions. And if you don't have, employee manuals and those kinds of things in place and written policies, an attorney can help you with that.
I would think so, and that would probably be a call that somebody should make right now. Because if you hire anybody, if you have any employees, you're liable for these laws, and you might just say, well, I'm paying you, and we don't have any issues between us right now, but you don't know what's coming a month down the road, a week down the road.
Well, sure. And then if if you have employees who are they're being fired or laid off and that are getting unemployment, then the rates that you have to pay for your premiums for unemployment insurance every quarter, those are going to start to climb up. So it's important to take steps to make sure that if somebody doesn't have a good case, they don't win, and that you have an attorney in place. So if you do have to go to a hearing or an appeal on those issues, that you've got the best chance possible.
And in today's environment, especially, I would guess if you don't have a company drug policy in place, you better get one written fast.
Absolutely. Absolutely.
And the attorney can help you with that.
That's a huge, and one of the biggest reasons I see for these cases. Yep.
All right, he's Marshall Chriswell, and we've been talking about issues of unemployment compensation from both ends, from the employees aspect and from the employers. And folks want to learn more from you about any of those topics. What do they need to do?
Go to the website at www.westernpalawyer.com. Or give me a call at 465-5826 or stop into the office in the Atrium Building in downtown Indiana.
It's AM 1160 WCCS 101.1 FM.